All right, rock stars. Now we're going to talk about how we have saved our clients over $500,000 by giving them customer contracts, their own customer contracts. All right, so most people, I think when you start a business, don't actually have a lot of experience working with a business lawyer or a team of business lawyers like we have. They don't know the value to that, they don't know how it works and what it costs and you don't know what you don't know, and that's fine. I certainly don't know a lot about surgery, for example. And so, there's that whole thing. But a business lawyer or team can be quite valuable, as we will show. It can be extremely valuable, and it's incredibly important for service companies or businesses that have mobile apps or terms and conditions. There's a lot of different terms for these customer contracts, so terms and conditions forms, click-through agreements if it's like a mobile agreement thing, service contracts. Us lawyers and CPAs, we have what are called professional engagement agreements or engagement letters. But whatever you call it, this is a contract that is unique to your business, between your business and your customers or clients or what have you, okay? It is tempting, I understand, to try and find an online version of a customer contract per se, but in our experience, that has not worked very well at all, because the business deal that you're making with your customers is probably unique to a large extent from people in your industry, but even your industry competitors, right, that are in the same industry with you. For example, if you're a marketing firm and you're creating some kind of digital content, right? If you're creating maybe a web frame for a website design, if you're creating, trademarks or slogans for them, right? Who owns the intellectual property that you're creating for them? Because on the one hand, they're paying you something for this service, but on the other hand, are they paying you enough for this service to where they should own all of this IP, right? So that type of question would make a business lawyer look at the customer contract that they signed, okay? And if it's valuable IP and they have not charged a rate to give you that IP, if you're this marketing firm, that means the marketing firm owns the IP, right? So you're sort of a partnership with this company. And then if that IP becomes very valuable, the marketing company that created the IP owns some of the IP, so some of the excess that this company would have would go to the marketing firm. Hope that makes sense. What are some other things in customer contracts that are really important? The choice of forum, if there's an arbitration provision or not. I can go on a big soapbox about arbitration. Generally speaking, I really don't like them. I don't think they're worth it. But also, choice of forum. What state's laws or jurisdictions' laws are going to apply here? Am I going to need to fly to, Chicago to litigate this contract if it becomes disputed, Or do I get to stay here in Georgia and make, the customer come over to Georgia and litigate it with me, right? So who's got to bear that expense of travel and finding a local attorney and on, right? What's the rate? What's the scope of the work, right? This is so important. Business clients of ours will get sued saying, oh, well, you promised me you would do A, B, C, and D. And if they have a good customer contract that says, no, you were only hiring us to do A and B. C and D was up to you or some other guy. But remember how we proposed C and D to you and you didn't, hire us for those things. And you signed this contract. So all that we're on the hook for is A and B. And you got A and B very well, but C and D you didn't, right? So you ask, how did we save our clients $500,000? Two ways. One is through litigation support. So the fact that our clients have been sued. A lot of these lawsuits were BS, but they certainly were going after a great deal of money, right? And every time we have been able to present that plaintiff bringing the lawsuit with our customer agreement that we wrote for them, and it shows very plainly that they were not at fault in the way that they were alleging. So they won those lawsuits, right? So that saved them money. Another big deal is chargebacks. These days, when a business is going under, I have found that they're very often issuing chargebacks through American Express or Visa or whoever it is. And the little guy, the small to mid-sized businesses, which are kind of our ideal clients, often get screwed by that because they can't present evidence of a contract having been made to the credit card company. But of course, if you have hired a business lawyer to write your customer contract and that customer agreed to that contract, and it doesn't have to be, a wet signature. It could easily be agreed to online through a click-through agreement or what have you. But as long as we show evidence of them having agreed to this contract and these terms and conditions, our clients typically win these chargebacks, which is great because chargebacks, that can be a lot of money. And when you win the case with American Express or what have you, just by showing them this contract that you wrote, it can be a pretty big win. So have your customer contracts or terms and conditions or engagement agreement or whatever it is written by an attorney. That's our advice. Yes, you can get things online, but they're not tailored to your unique business. If you're an entrepreneur, if you call yourself an entrepreneur, you probably have somewhat of a unique business, which takes its own, terms and conditions, literally. Like you make deals with your customers that are different from, your competitors, right? So we got to put that into the contract. Otherwise it's not enforceable, as we say. So keep rocking and rolling, guys. That's all for this lesson. If you want us to look over any of your customer contracts or, a dispute or anything like that, give us a holler, sparkslawpractice.com. All right, keep rocking and rolling.